Hello everyone. So in today's video we'll be discussing MCQs of Indian Evidence Act. So let's start with the video. Question number 1. The Bill of Evidence Act was prepared by option A, Fourth Law Commission, option B, Sir Henry Maines, option C, Sir James Stephen, option D, none of the above. The correct answer to this question is option C, that is Sir James Stephen. Question 2. Indian Evidence Act applies to option A, civil proceedings only, option B, criminal proceedings only, option C, both civil and criminal proceedings, option D, none of the above. The correct answer to this question is option C, both civil and criminal proceedings. Question number 3. As per preamble of Indian Evidence Act 1872, the purpose of this act is option A, to provide, define and amend the law of evidence. Option B, to provide, consolidate the law of evidence. Option C, to define and amend the law of evidence. Option D, to consolidate, define and amend the law of evidence. The correct answer to this question is option D, that is to consolidate, define and amend the law of evidence. Question 4. The law of evidence is option A, substantive law, option B, procedural law, option C, only natural law, option D, all of the above. The correct answer to this question is option B, that is procedural law. Question number 5. Select the incorrect statement using the code given below. First, Indian Evidence Act does not apply to arbitration proceedings. Second, the Indian Evidence Act does not apply to proceedings before a commissioner appointed by the court for recording evidence. 3. The Indian Evidence Act applies to affidavits presented to courts. 4. The Indian Evidence Act applies to judicial proceedings held before all kinds of military court. The codes are given in the following options. Option A, 2 and 3 are incorrect. Option B, 2, 3 and 4 are incorrect. Option C, 1 and 3 are incorrect. And option D, none of the above. The correct answer to question number 5 is option number B, that is 2, 3 and 4 are incorrect. The first one is the correct option, as the Indian Evidence Act does not apply to arbitration proceedings. We can see this thing in section 1 of Indian Evidence Act itself. Next, question number 6. The law of evidence consists of which one of the following? Option A, ordinary rules of reasoning. Option B, legal rules of evidence. Option C, rules of logic. Option D, all of the above. The correct answer to this question is option B, legal rules of evidence. Question number 7. Point out the wrong answer. The Indian Evidence Act, option A, applies to court-martial convened under Army Act, Naval Discipline Act, Indian Navy Act 1934 or the Air Force Act. Option B, does not apply to proceedings before an arbitrator. Option C, applies to all judicial proceedings. Option D, does not apply to affidavits presented to any court or officer. So now in this question we need to point out the wrong answer. So the correct answer to this question is option A, that is applies to court-martial convened under Army Act, Naval Discipline Act, Indian Navy Act or Air Force Act. Next, question number 8. The term court used under Indian Evidence Act 1872 includes option A, all judges but not magistrates. Option B, all magistrates but not judges. Option C, all judges, magistrates, persons except arbitrators legally authorized to take evidence. Option D, all inquiry and investigation officers and arbitrators legally authorized to take evidence. The correct answer to question number 8 is option C, that is court. The term court used in the Indian Evidence Act includes all judges, magistrates, persons except arbitrators legally authorized to take evidence. Question number 9. Which one of the following does not fall within the definition of the term court under Indian Evidence Act? Option A, all judges. Option B, all magistrates. Option C, all the consumer forums. Option D, all persons legally authorized to take evidence. The correct answer to this question is option C, that is all consumer forums. This doesn't fall under the definition of the term court given under section 3. Moving forward to question number 10th. On which one of the following dates Indian Evidence Act 1872 was passed? Question number option A, 15th March 1872, option B, 1st September 1872, option C, 1st July 1872, and option D, 1st February 1872. The correct answer to question number 10th is 15th March 1872. Question number 11th. Indian Evidence Act came into force on option A, 1st September 1872, B, 1st January 1872, C, 9th September 1872, D, 9th January 1872. The correct answer to question number 11th is option A, 1st September 1872. 12th. The Indian Evidence Act applies to option A, affidavits, option B, departmental proceedings, option C, arbitration proceedings, option D, an inquiry to determine jural relation between persons. The correct answer to question number 12th is option D, an inquiry to determine a jural relation between persons. Next, question number 13. Electronic records were included in section 3 of the Indian Evidence Act. Option A, 17th October 2000. Option B, on 10th October 2000. Option C, 2 October 2000. And option D, 14th November 2000. The correct answer to question number 13 is option A, 17th October 2000. Question number 14. Indian Evidence Act does not apply to option 1, proceedings before the arbitrator. Option 2, affidavit submitted by the deponent of his own. Option number 3, statements made by a child. Option number 4, statements of a person whose past is criminal. So now select the correct answers using the code given below. So option 1 is 1 in 4, B 1 in 3, C 1 and 2, D only 2. So the correct answer to question number 14th is option number C, that is 1 in 2. Question number 15th. The Indian Evidence Act is not applied to option A, affidavits presented to court, B, proceedings before an arbitrator, option C, both A and B, option D, judicial proceedings before court. So the correct answer to question number 15th is option C, both A and B. Question number 16. Point out the incorrect answer. Evidence may be option A, direct and indirect, B, primary and secondary, C, oral and documentary, and D, procedural and substantive. So the correct answer to question number 16 is option D. Option D is the incorrect one. That is procedural and substantive. Evidence are not procedural or substantive. Question number 17. The meaning of Lex Loci is option A, law of the land is supreme, B, law of land, option C, local laws, option D, law of England. So the correct answer to question number 17 is option B, law of land. Question number 18. Law of evidence was enacted to option A, do away with the judge made law as in England, option B, help the courts come to some conclusion about the facts of the case, option C, ending the judicial autonomy in admitting evidence, and option D, all of the above. So the correct answer to question number 18 is option B, that is law of evidence was enacted to help the courts come to some conclusion about the facts of the case. Question number 19. Which of the following is law considered as the basis of Indian Evidence Act 1872? Option A, law of place where act was done or offence was committed. Option B, law of the place where investigation or inquiry was conducted. Option C, law of the place where solution was found by the parties. Option D, law of the place where proceedings have to be initiated in a case. So the correct answer to question number 19 is option D, law of the place where proceedings have to be initiated in a case. That is Lex Loci. Question number 20. Which evidence is not admissible? Option A, oral evidence. Option B, evidence by affidavit. Option C, documentary evidence. Option D, evidence of expert. The correct answer to question number 20 is option B, evidence by affidavit. Question number 21. The affidavit given to the court is option A, not evidence, option B is evidence, option C, merely a written statement, option D, a proof. The correct answer to question number 21 is option A, not an evidence. Question number 22. The Indian Evidence Act 1872 applies to option A, the whole of India including the state of Jammu and Kashmir, option B, all judicial proceedings in or before any court, option C, proceedings before an arbitrator, option D, affidavits presented to any court or officer. The correct answer to question number 22 is option B, that is, an Indian Evidence Act applies to all judicial proceedings in or before any court. Question number 23. Indian Evidence Act 1872 applies to option A, proceedings before a tribunal, option B, proceedings before an arbitrator, option C, judicial proceedings in court, option D, all of the above. The correct answer to question number 23 is option C, that is, judicial proceedings in court. Question number 24. Indian Evidence Act deals with 1. Relevancy of evidence, 2. Reliability of evidence, 3. Admissibility of evidence. The correct answer, select the correct answer using the code given below. So the codes are given in the following options. Option A says 1 and 2 only, option B says 1 and 3 only, option C says 3 only, and option D says 1, 2 and 3. So the correct answer to question number 24 is option B, that is 1 and 3. Next, question number 25. Which of the following is or are the correct statements? Option A, evidence excluded by the Evidence Act is inadmissible, even if it seems essential for ascertainment of truth. B, parties cannot contract themselves out of the provision of Evidence Act. Option C, both A and B. Option D, neither A nor B. So the correct answer to question number 25 is option D, neither A nor B.